WA claims to own structure on my property but has no easement proving access. Edit for location box, North Carolina, USA. Please don't judge me for owning a house within WA. I promise you I tried my best to avoid it, but it just wasn't possible. I purchased a house earlier this year. Apparently, when the WA was very first being built 25 years ago, they built a structure that was intended to be used by the community, and that would require an easement on what has become my property for access. However, my plot and my neighbor's plot were some of the last to sell, and no easement was actually recorded on the deeds to these properties when that happened. Perhaps it was an administrative mistake. It's not clear. The previous owners of my home, as well as the previous owners of the neighboring home, put up no trespassing signs and had essentially been using the structure as private use, shared between the two of them. When I bought the house, I was given a copy of an agreement signed between the previous owner and the neighbor, essentially giving each other easement access to the structure. It's right on the property line, and agreeing to split a cost of maintenance. That agreement did not mention the HOA's involvement in any way, and I assumed that the two owners had built the structure themselves. Though now looking closely, it doesn't technically say that. I was recently contacted by the WA, explaining that they owned the structure and they were hoping to resolve all this by having me and/or our neighbors grant them an easement. I in no way want that to happen. I have reached out to my title company but don't even really know what to say because I'm not sure. The WA is actually making a legal claim at this point. My questions are there any situations where I would be forced to grant them the easement that they want? Also, do they still have any right to the structure itself? Like maybe the materials used? If they do try to make a legal claim, would my title insurance get involved or would I need to hire a lawyer? I'm really hoping I can just tell them to go pound sand. You are not required to grant an easement to the WA. Your title makes no mention of the WA. Their fault for not recording it properly. Your WA does not own anything on your land despite what they claim. Your title is what matters. I've dismantled the structure entirely and removed this issue before granting anybody an easement. They can ask you and your neighbor for an easement and you can say no. They can offer to pay you for an easement and you can still say no. Could you claim adverse possession as a backup plan? Have you, your neighbor, paid taxes on the land? Who has paid for upkeep of the structure? IANAL. The depreciated value of the structure must be somewhere close to zero. Presumably the prior owners of your house, and the current and any prior owners of your neighbor's house have shouldered the burden of maintaining this gazebo dock structure for the entirety of its existence. This too weighs in favor of you and your neighbor being the sole owners of that little amenity. If the WA wrote a letter, email to you, I would advise getting an attorney or your title company to respond on your behalf. It would be better if the title company did it because it will be clear to the WA that they are now playing in the major leagues. There may well be a statute of limitations in North Carolina that effectively ends this dispute before it starts. The last thing you want is everyone in the neighborhood traipsing all over your property. The place I would likely start is with a full title search of your property. Just because your deed doesn't specifically mention easement, it likely includes some reference to all easements of record that might be sufficient to get the WASM right here. Talk to a local real estate lawyer. The fact that the prior owners also treated it like it was private solidifies your right to it. Seems like a liability issues if something was to happen on the lake. I'd tell them no. I would have a lawyer look into adverse possession. The legal doctrine known as adverse possession allows trespassers who openly inhabit and improve an otherwise abandoned piece of property to gain title to that property after certain conditions are met. For instance, North Carolina's adverse possession laws require an individual to occupy an otherwise neglected property publicly for at least 20 years, or 7 years with color of title, meaning he or she has reason to believe they have the right to possess the property. https://north-carolina-laws/north-carolina-adverse-possession-laws.html.
If you enjoyed this video, please check out our playlists full of similar content. Epic Haircast is like doom scrolling for your ears. Please like, share, and subscribe.